Welcome to E-Pathshala. I'm Dr. Shruti Bedi from the University Institute of Legal Studies, Punjab University. The module describes the functions provided under the Constitution regarding the establishment of a transparent system of government. The Constitution of India provides certain socio and economic goals for the citizens of this country. The citizens have been reassured and guaranteed certain rights which the executive in the country is supposed to take care of. The Constitution therefore provides a certain ambit of transparency in the working of the systems of institutions of transparency in India, and the people therefore look forward to a transparent functioning and the exercise of powers by these institutions. The module will be discussing the various powers, functions, and duties of the three main organs which deal with institutional transparency in India, that is, the Central Vigilance Commission, CVC, the Comptroller and Auditor General of India, the CAG, and the Central Information Commission, that is the CIC. All these institutions are involved with looking after the rights of the citizens and the working of the government in a transparent and effective manner so as to promote good governance. Public governance relates to the process by which a society organizes its affairs and manages itself. In democracies, public governance is a complex matrix of relationship that exists between the institutions and civil society regarding the responsibility and accountability for the management and control of public resources and delivery of public services. Governance implies effective management of public resources, high level of accountability and transparency, and free flow of information, control of corruption. Significant citizen participation and equity are the quintessential principles of democratic institutions. Since around the 1990s, transparency became a maxim for national governments, international institutions, and civil society groups around the world. Nobel Prizes have been awarded for bringing attention to the importance of information in the functioning of the markets. George Akerlof, Michael Spence, and Joseph Stiglitz received the Nobel Prize in 2001 for their analysis of how imperfect information can lead to market failures. Amartya Sen won the 1998 Nobel Prize for illustrating the role of information and entitlement in the functioning of the markets. His extensive research on famines in the Great Bengal, Sahel, Bangladesh, and Ethiopia showed that famines had occurred in years when the supply of food was not significantly lower than the during previous years. The problem was not the shortage of food, but lack of information and voice of the people. People will starve when their entitlement is not sufficient to buy food necessary to keep them alive. The towering conceptual contributions of the Nobel laureates in putting forth a framework linking the citizenry's right to know and to access to information with development are undisputable and have already had a significant influence in various fields. In fact, transparency is widely recognized as a core principle of good governance. Free access to information is a key constituent in promoting transparency, but the information must be timely, relevant, accurate, and complete for it to be used effectively. Transparency and accountability in government are mutually reinforcing. However, actual implementation of transparency-related reforms on the ground, while not devoid of stellar examples and progress in some countries, remains checkered globally. Information is valuable also to the electorate for democratic processes to function effectively. Citizens have an interest in knowing about government actions and processes, allocation and redistribution decisions, market barriers and restrictions, tax and subsidy incidences, and so on. Not only do these factors affect the economic performance of market activities, they affect the political support the voters may offer to incumbent policy makers. The institutions of transparency in India. The paradox in Indian institutional framework to ensure transparency and thereby accountability is inescapable. The de jure policies may appear to be all in place, and yet in the de facto implementation and delivery there is rampant corruption absenteeism, indifference, incompetence, inefficiencies, outright failures. At the heart of these failures is a systematic crisis of accountability. In fact, some observers have argued that the Indian state, its institutions, and the rules that govern them are structured to avoid accountability altogether. There are various bodies in place for ensuring transparency and accountability. At the federal level, key institutions include the Central Vigilance Commission, the Office of the Comptroller and Auditor General, and the Chief Information Commission, which we will discuss in this chapter. In India, these institutions comprise of financial oversight bodies like the Comptroller and Auditor General, investigative agencies like Central Vigilance Commission. Independent agencies such as these increase the ability to commit to desirable policies and increase transparency in the sense that specialization makes the agent responsible more easily and identifiable. Transparency is sometimes in tension with responsiveness and representation in tension with both. The crucial point is that harmonizing the different components of accountability cannot be done by conceptual fiat. It is an empirical matter addressed by institutional design and the concrete work of politics. The first, Central Vigilance Commission. Anti-corruption measures of the central government are a responsibility of Administrative Vigilance Division in the Department of Personnel and Training, Central Bureau of Investigation, Vigilance units in ministries, departments of governments of India, central public enterprises, and other autonomous organizations. Disciplinary authorities, the Central Vigilance Commission. The Administrative Vigilance Division was set up in the Ministry of Home Affairs in August 1955 to serve as a central agency to assume overall responsibility for anti-corruption measures. With the establishment of the Central Vigilance Commission, a good part of the functions performed by the Administrative Vigilance Division are now exercised by the Central Vigilance Commission. The Administrative Vigilance Division is now responsible for the formulation and implementation of policies of the central government in the field of vigilance, integrity in public services, and anti-corruption, and to provide guidance and coordination to ministries, Department of Government of India in matters requiring decisions of the government. In pursuance of the recommendations made by the Committee on Prevention of Corruption, popularly known as the Sanatam Committee, the Central Vigilance Commission was set up by the Government of India by a resolution dated 11th February 1964. The serious concern expressed by many members of the Parliament in the parliamentary debate in June 1962 on the growing menace of corruption in administration led to the formation of the Committee on Prevention of Corruption, better known as Sanathanam Committee, to review the problem and make suggestions. Among other things, the Sanathanam Committee noticed the conspicuous absence of a dynamic integration between the vigilance units in various ministries and Administrative Vigilance Division in the Ministry of Home Affairs. The committee also raised an important issue that the administration could not be a judge of its own conduct. Consequent upon the judgment of the Supreme Court in Vineet Narayan versus Union of India of 1993, the Commission was accorded statutory status with effect from 25th August 1998 through the Central Vigilance Commission Ordinance 1998. Subsequently, the CVC Bill was passed by both Houses of Parliament in 2003 and the President gave its assent on 11th of September 2003. Thus, the Central Vigilance Commission Act 2003 came into effect from that date. The establishment of the Commission was considered fundamental for evolving and applying common standards in deciding cases involving lack of probity and integrity in administration. In terms of the provisions made in the CVC's Act, the Commission consists of a Central Vigilance Commissioner, who is the chairperson, and not more than 2 Vigilance Commissioners, who are the members. The Central Vigilance Commissioner and the Vigilance Commissioners are appointed by the President for a term of 4 years or till they attain the age of 65 years, whichever is earlier. The basic powers and functions of the Commission, as defined in Chapter 3, Section 8 of the CVC Ordinance 1998. Section 24 of the Ordinance also envisages that the Commission shall continue to discharge its existing functions as per the Resolution of Government of India 1964, which are not inconsistent with the provisions of the Central Vigilance Commission Ordinance 1998. The Commission is deemed to be a civil court for the purposes of Section 195 and Chapter 25 of the Code of Criminal Procedure 1973, and every proceeding before the Commission is to be a judicial proceeding within the meaning of Sections 193 and 228 and for the purposes of Section 196 of the Indian Penal Code. The task of the CVO is not limited to interfering after faults and inaccuracies have been committed. The foremost object of his office is to thwart slip-ups. The Sanathanam Committee, while outlining the preventive measures that should be taken to significantly reduce corruption, emphasized 4 major causes of corruption and how, in respect of each of these causes, preventive measures could be planned and implemented in a sustained and effective manner. These causes are: number 1, administrative delays; 2, government taking upon themselves more than what they can manage by way of regulatory functions; 3, scope for personal discretion in the exercise of powers vested in different categories of government servants; 4, cumbersome procedures of dealing with various matters which are of importance of citizens in their day-to-day affairs. The role of the Chief Vigilance Office may broadly be divided into 2 parts, that is, preventive and punitive. The Chief Vigilance Officers have so far been concentrating mainly on the punitive side, that is, dealing with actual vigilance which has not received adequate attention. The word vigilance entails watchfulness. The role of the vigilance officer is predominantly preventive, and the use of adjective preventive before the word vigilance is, strictly speaking, redundant. While detection and punishment of corruption and other malpractices is certainly important, what is even more imperative is the taking of preventive measures which could lessen the number of vigilance cases considerably. The proactive approach by the CVC is the call of the day, seeing the glaring misconduct set within the system. These measures include a detailed examination of the existing organization and procedures with a view to eliminate or minimize factors which provide opportunities for corruption or malpractices, planning and enforcement of regular inspections, surprise visits for detecting failures in quality or speed of work which could be indicative of the existence of corruption or malpractices, location of sensitive spots, regular and surprise inspections of such spots, and proper scrutiny of personnel who are posted in sensitive posts which involve dealings with members of the public on a considerable scale. Maintaining proper surveillance on officers of doubtful integrity and officers who are on the agreed list. Ensure prompt observance of conduct rules relating to integrity covering statements of facets and acquisitions, gifts, relatives employed in private firms or doing private business, and Benami transactions. On the punitive side, the Chief Vigilance Officer's responsibility can be: number 1, to ensure speedy processing of vigilance cases at all stages. In regard to cases requiring consultation with the Central Vigilance Commission, a decision as to whether the case has a vigilance angle shall in every case be taken by the CVO, who, when in doubt, may refer the matter to his administrative head, that is, Secretary in the case of ministries or departments and Chief Executive in the case of public sector organizations. Number 2, to ensure that charge sheet, statement of imputations, lists of witnesses and documents, etc. are carefully prepared and copies of all the documents relied upon and the statements of witnesses cited on behalf of the disciplinary authority are supplied whenever possible to the accused officer along with the charge sheet. 3, to ensure that all documents required to be forwarded to the inquiring officer are carefully sorted out and sent promptly. 4, to ensure that there is no delay in the appointment of the inquiry officer and that no dilatory tactics are adopted by the accused officer or the presented officer. 5, to ensure that the proceeding of the inquiry officer's report for final orders of the disciplinary authority is done properly and quickly. 6, to scrutinize final orders passed by the disciplinary authority subordinate to the ministry or department with a view to see whether a case for review is made out or not. 7, to see that proper assistance is given to the CBI in the investigation of cases entrusted to them or started by them on their own source of information. 8. To take proper and adequate action with regard to writ petitions filed by accused officers. 9. To ensure that the Central Vigilance Commission is consulted at all stages where it is to be consulted, and that as far as possible the time limits prescribed in the Vigilance Manual for various stages are adhered to. To ensure prompt submission of returns to the Commission, and to review from time to time the existing arrangements for vigilance work in the Ministry Department for Vigilance Work subordinate to officers to see if they are adequate to ensure expeditious and effective disposal of vigilance work. To ensure that the competent disciplinary authorities do not adopt a dilatory or law attitude in processing vigilance cases, thus knowingly or otherwise helping the suspect public servants, particularly in cases of officers due to retire. To ensure that cases against the public servants on the verge of retirement do not lapse due to time limit for reasons such as misplacement of files, etc., and that the orders passed in the cases of retiring officers are implemented in time. To ensure that the period from the date of serving a charge sheet in a disciplinary case to the submission of the report of the inquiry officer should ordinarily not exceed 6 months. Information about corruption, malpractices or misconduct comes from the CVO from diverse sources. The CVO is also expected to scrutinize report of parliamentary committees like the Estimates Committee, Public Accounts Committee and the Committee on Public Undertakings and Audit Reports. Proceedings of the two houses of Parliament and complaints and allegations appearing in the press relating to his own organization, and to initiate action whenever any case having a vigilance angle comes to light from any of these sources. In particular, the CVO scrutinizes the PAC reports in detail even when such reports come to the organization at the draft state, with a view to see if any public servant might have acted for an improper purpose or in a corrupt manner, or had exercised his powers for corrupt or improper purposes, and the Central Vigilance Commission be kept informed. Number 2. Comptroller and Auditor General. The Office of the Comptroller and Auditor General, the CNG, is the apex auditing body. The CANG have produced several reports on various departments such as railways, public sector enterprise and tax administration. The Comptroller and Auditor General of India plays a key role in the functioning of the financial committees of Parliament and the state legislatures. The Constitution enables the independent and unbiased nature of audit by the CAG by providing appointment by the President of India, special procedure for removal like the Supreme Court judge, salary and expenses charged not voted upon, cannot hold any other government office after his term expires. The organizations subject to the audit of the Comptroller and Auditor General of India are the All India Union and state government departments and offices, including the Indian Railways and Posts and Telecommunications, about 1,500 public commercial enterprises controlled by the union and state governments, that is, government companies and corporations, around 400 non-commercial autonomous bodies and authorities owned and controlled by the union or the states, over 4,400 authorities and bodies substantially financed from union or state revenues. Today, the scope of CAG is not just limited to the financial affairs but has increased significantly, encompassing in it the objective of controlling corruption, preventing wasteful government expenditure and fostering excellence in the public sector. These reports have revealed many financial irregularities, suggesting a lack of monitoring of public expenses, poor targeting and corrupt practices in many branches of government. The most recent example is its report on the 2G scam and coal allocation scam that nailed the corrupt organizing committee members and government representatives. CAG hitherto has played a significant role in alleviating issues of corruption, black money, government's anti-public policies and other challenges for good governance. Instances such as improper implementation of Ganga Action Plan 1, the inflated accounts of Food Corporation of India for the year 1997-82, the financial mismanagement in Bihar in the year 2000 to 2003 brought out by CAG prove that its office, since its inception, has been playing a crucial role in achieving the goal of good governance. Yet the recent cases of Commonwealth Games, 2G Spectrum scam, reports menace or aggravating losses of Air India established the need for aggressive execution of CAG's authority. Adarsh housing scam and more recently the Colgate. The duties of the CAG as defined by the DPC Act 1971 are to audit and report upon all receipts into and spending from the coffers called the Consolidated Fund of the Union and State Governments, all transactions relating to emergency expenses called contingency funds and relating to the monies of the public held by the government, example postal savings, Vikas Patras called public accounts at central as well as state levels. All trading, manufacturing, profit and loss accounts, balance sheets and other subsidiary accounts kept in any government department. All stores and stock accounts of all government offices and departments, accounts of all government companies and corporations, example ONGC, SAIL, etc., accounts of all autonomous bodies and authorities receiving government money, example municipal bodies, IIMs, IITs and state health societies, accounts of any body or authority on request of the President or Governor or on his own initiative. The CAG has the power to inspect any office or organization subject to its audit, power to examine all transactions in question the executive, power to call for any records, papers, documents from any audited entity, and the power to decide the extent and manner of audit. The CAG's oversight audit functions in India have traditionally focused on ensuring that government entities are spending funds prudently as intended by the Parliament and complying with applicable laws, rules and regulations while guarding against loss due to waste, misuse, management, abuse, errors, frauds and other irregularities. Number 3. The Chief Information Commission. The Chief Information Commission was established in 2005 and came into operation in 2006. Information commissions sit at the crossroads between the rights of the public and duties of officials. As such, it is essential that their judgments are consistent, well adjusted, and can stand up to scrutiny by the courts, the public, and officials. At a minimum, all decision notices need to be collected internally into a central database so that commissioners and staff can easily refer back to previous decisions. Decisions need to be collected and filed even if they are issued summarily as a short order, as well as when they involve complex legal points and take up the form of more detailed judgments. State information commissions have also been set up, thus giving practical shape to the 2005 Right to Information Act. It is expected that the CIC will help spread the culture of public seeking information under the RTI and expose wrongdoings. Section 1910 of the Act specifically requires that information commissions and or the government nodal agencies are responsible for administering the RTI Act, and they will need to develop rules which provide more detail on how appeal will be made and processed. Some jurisdictions have already promulgated appeal rules. Section 18(1) gives information commissions a very broad review remit to consider issues not only regarding disclosure but regarding the calculation of fees, forms of access, imposing penalties and awarding compensation. Section 24(1) also gives information commissions a role in determining when information should be released by intelligence or security agencies exempted under Section 24(1), where it is claimed that information sought is in respect of allegations of violations of human rights. As a consequence of the breadth, the oversight remit of information commissions, internal procedural guidelines also need to address the different challenges that are thrown up by different types of cases the commissions will handle. Section 19(5) of the Act specifically places the burden of proving that withholding information was justified onto official who denied the request. It is essential that the Information Commission remains user-friendly and does not turn into another overly legal forum which is dominated by lawyers. Although the Commission does have powers of a civil court under 18(3) of the Act, nonetheless, the Commission is not expected to operate like a court. The main goal of setting up the commissions was to provide an alternative to the courts which was cheap and easy to use for ordinary people. Section 25(3) specifically requires the information commissions produce annual reports. Through their annual reports, information commissions can provide a holistic picture of the status of compliance with the Act. They can highlight areas of good and bad practice, lessons learned and innovations which could be replicated. They can also pinpoint areas for reform. One of the key provisions of this Act is self-disclosure of information in public domain. It is assumed that if adequate information is available, citizens can demand services and claim rights due to them from appropriate authorities and officials. The status of self-disclosure is rather poor nationwide. In conclusion, I would like to say that the institutions established in India for promoting transparency in governance through the executive are functioning in a well-defined manner. However, there may be lacunas and existing problems and issues which arise during the course of their functioning, which still need to be looked into and rectified by the government. However, it is indeed commendable that the government has made a gigantic leap towards providing more and more transparency to the citizens of India through the procedures of vigilance, providing them information through the Right to Information Act, and continuing an audit of the governance functions of the government. It, however, remains to be seen how effective are the powers and functions that are exercised by these three organs as discussed, that is the Central Vigilance Commission, the Central Information Commission, and the Comptroller and Auditor General of India. Thank you.